welcome everybody to the meeting of the State Board of Canvassers and State Board of Elections. We're going to open today's meeting as the State Board of Canvassers. My name is Peter Kaczynski. To my right is Doug Kellner. To my far right is Andy Spano. And to my left is Greg Peterson. And I would open as the Board of Canvassers today to certify the special election results from April 24th of this year. And Bob, do we have the documents?
We do. First, we'll start with the state senate. We're certifying the 32nd Senate District and the 37th Senate District. These have all been done informally, but this is the final cert, so each of the commissioners signs the brown one.
So I guess first I'd entertain a motion to adopt the results as given to us by the staff.
So moved.
A second?
Second.
All in favor?
Aye.
Opposed? So that's adopted. And now we'll sign the documents.
Times are getting cheaper.
Are they?
Times are tough.
Times are tough.
They actually flow very well.
There you go.
I'll get better ones for next time.
All right, so
So in the assembly, we have the 5th, 10th, 17th, 39th, 74th, 80th, 102nd, 107th, and 142nd district.
so I make the same motion that we certify.
Second.
All in favor?
Aye.
Opposed? So it's also adopted.
Andy hasn't signed
It did.
that. Oh, I'm sorry.
Yeah, he signed. Is there any other business to come before the Board of Canvassers? If not, I would entertain a motion to adjourn.
So moved.
Second, all in favor?
Aye.
That's adopted. Now we will now open as the Board of Elections. And our first order of business is to adopt the minutes of May 3rd. We have two sets of minutes. One is from May 3rd and one is from May 8th. You want to take them together or separately?
We can do it together.
All right, so I would entertain a motion to adopt both sets of minutes.
So moved.
Second. All in favor?
Aye.
Opposed? So those two sets of minutes are adopted. Next, we will go on to unit updates. The first unit is Executive Bob Brem and Todd Valentine.
Well, tomorrow is federal primary, so we've been getting our preparations ready for that from the counties. We certified the election quite a while ago, or the candidates rather, but tomorrow is actually election day. And we are as ready as we can be for that. So, and what we've been doing though over the last month is instituting.
How many primaries are there, Bob? I'm sorry, Todd, how many?
There are 20 and 15 districts.
There's 20 primaries and 15 congressional districts?
Yeah.
I'm not sure how many counties that covers. It's not the entire
I
state.
didn't, no, it's not.
It's like 48, I think.
So most of the state, got it.
So we prepared our system for election and reporting, for the counties, and we'll be prepared to receive those results from the counties, tomorrow night, and they should be posted on their website, so. We're ready. We've been working over the last month since we adopted our cybersecurity plan. As you know, we did a series of 6 exercises to try to engage the counties with their own IT departments and us with them, and as also with a lot of support from the Federal Department of Homeland Security. We covered 60 counties, 60 counties over 6 exercises. So that's almost everybody, so that was pretty good. Something I'm sure we'll repeat, not next year, but probably sometime in future in the following year. But related to that, we've also, and Bill Cross can report on this more later, we successfully moved our data center from the CNSE building to the Zen building, which is the same campus uptown. And we've also did complete the upgrade of NYSBOE, which has been long talked about. So that finally went online pretty smoothly. So, and then Bob, I know, has developed a list of how we did at the end of the session, so I don't know if you wanted to go over that.
I did a quickie review. We have, let's try to find the number. We had 29 legislative priorities this year. Of that number, 18 were introduced in the Assembly, 8 were introduced in the Senate. Of the action, 14 passed the Assembly. There were many that made it to third reading in the Senate, but they didn't come out at that point. And some that passed, we don't have sponsors in the other house, so certainly that'll give us something to focus on for our next legislative year, where we could try and pick up some support. So there was a lot of activity. It just didn't gel at the end to chapters. I think the only chapter we saw was chapter 3, which set the September 13th primary date for us. And I don't think there's anything else that is election related that passed both houses that is pending, but there could have been something that snuck through there at the end, but I don't think so. So the legislative activity has gone on. The other item we did, we took the approved cybersecurity plan and submitted it to the Federal Election Assistance Commission to receive New York State's share of the money, which was just shy of $19.5 million. They accepted our application and wire transferred the money to the state of New York. So now we can begin to use those funds to improve the election. And from our perspective, we're doing the staffing plan that was part of the approval process. We have posted those positions that are exempt on the website for the state jobs. We're getting those resumes and interested individuals, start the interview process for staff. We're also working to put the final touches on 3 procurements for the risk assessments at the county level and for the intrusion detection monitoring systems. Oh, sorry.
Oh, I'm sorry. This one here?
I think both, thank you.
These two?
Yep. Ears blocking the sound.
Okay. How's this?
Should be fine.
That should be fine.
Okay.
Probably block Todd's side.
Okay. Better?
It's better, thank you.
Okay. All right. Sorry. Go ahead, Bob. You have to start from the beginning of it. No one heard anything you just said. So
we certified, so the money is in the state coffers, which is faster, as you know, when you had to apply for the federal funds too. This round of funding is faster, streamlined as far as obtaining the money. It's different in other federal funds in that this is 5-year federal grant money. It's not treated the same as other Help America Vote Act funds. At the end of 5 years, if we have not spent the money, it will go away. So we have, of course, under our plan, we expect it to be spent within 3 years, so we don't think that's a problem. But it's different, and we have to track it different than the other funds. They're not forever dollars. But we have, we've been working with a group of people to put together the risk assessment procurement to be able to check every county at a uniform level of risk assessment, and also intrusion detection services to make sure that all the counties that need that help will have the ability to purchase off that contract, or we will pay for the devices that are needed to make those counties and the state board safe off of those, and those we believe we'll be able to get out there relatively quickly. There will be, once we get that accomplished, there'll be other areas of work that we need to do, but that's a pretty good start since our last meeting.
Is that it? Any questions? Okay, then we will move on to the next unit, which is the council's office, Kim, Galvin, and Brian Quayle.
Thank you, Commissioner. We've worked with IT to develop a database for the independent expenditure filings that we're anticipating. Brian's PETA's. They're doing a great job. I'm sure Bill can update us more on creating the database and what it's going to look like. There is some work the compliance unit has to do with regard to getting things in accessible formats like the reg docs and things like that, and we're starting to assign people to do that and looking at the forms, as well as they've agreed to final settlement terms on the Easton accessibility case with the website. That seems to be a project that's going to take a rather agency-wide effort to bring those various documents and archived documents, et cetera, into compliance. So there's been meetings on that. We've met and reviewed briefly the comments that we have received on the 2 pending regulations that will be right for adoption at the next meeting on the independent expenditure filings again and the pay on the enforcement regulations and the IE filings. We've gone over them with regard to the IE expenditures. I know that we're anticipating late last week the broadcaster sent us the delineation between 50 million unique monthly visits and up to 137 million, like I believe Commissioner Kellner asked Jeff Keely at the last meeting. They did send that to us late. It hasn't been circulated. We haven't discussed that particular part of it yet. And I got a call from Facebook, or the person representing Facebook over the weekend, a text that they too would like to talk again in this coming week. I think now that the legislative session has ended, they've kind of focused their attention back to us on that particular issue. With regard to the cases, just briefly, we responded to the Brennan Center's motion to leave to appeal to the Court of Appeals. Those papers have been filed. An injunction received in the Merced witness case to get us through the election. Easton, as mentioned above, is taking a group effort, particularly Bill Cross's staff. That's all I have with regard to those. We're anticipating the filing period starting on July 9th. Since our last meeting, the governor's office, this is separate as its own item on D, but I thought I would just bring it up in the my unit report because it's just an update. Since our last meeting, the governor's office has issued at least its first round of voting pardons, and we've been answering many questions on that issue from county boards of election and just some citizens. From our discussion with the governor's office back when this first started, we're anticipating that there'll be another round of voting pardons issued each month, and the co-executive directors sent out guidance to the county boards of election on how to deal with that in the first instance, should the circumstance arise. Since then, I believe the governor has issued a directive to his parole staff to deliver hard copies of the pardon to those placed on community supervision, either in a home visit or at their next scheduled meeting date.
Kim, let me ask you a question on that, if I could. Let me just conjecture for a minute that a parolee is now given the ability to vote, but part of their condition of parole is they can't go to a school, and their voting site is at a school. How does that get resolved?
Well, based upon the circumstances, the governor's office indicated that the parole conditions would not be trumped by the conditional voting pardon. So if one of my conditions as someone under community supervision was to stay away from a school and my polling place happened to be at a school, essentially they wouldn't be able to vote. Unless it's really a parole issue. So what we told with probationers often is look, this is a condition of your parole. If you can get your probation officer to accompany you or do something at 6 a.m. or something, that's between you and parole. And then you're allowed to vote. Technically, they can't issue or can't vote by absentee ballot because they're not out of the county. So they are kind of stuck in an odd position if that's the circumstance. So you may have some sex offenders or drug offenders or whomever, for whatever reason, may have a school or a community center condition in there. And lastly, it's kind of a sad week in our unit here with Brian and I. Our two trainers, Mary Ellen Walsh and Lorraine Del Costello, are both retiring. They will be missed. While we wish them well, their professionalism, their experience, and their personalities will be missed agency-wide. They're two very fine people, and they brought an awful lot to the table. And I wish them well. We all wish them well in their next stage of life. So.
And they were good spec checkers.
And they were good spec checkers, and they picked that's probably why they picked this one, actually. So that's a hole in the unit that we'll endeavor to fill.
A couple ads, if I may. Just in the area of the cases, the common cause case, our motion to dismiss remains pending, but we did get a directive from the court to issue a supplemental brief on the possible impact of a recent Supreme Court decision on that case, and those papers are due later this week. In the upstate jobs case, we were successful in opposing an application for a preliminary injunction, and that, however, is on interlocutory appeal with the Second Circuit, and our papers there are also due later this week. Which segues into the Supreme Court of the United States. We had 3 decisions that are related to elections that came out of the United States Supreme Court since the board last met. And with respect to one of them, the Minnesota case that dealt with electioneering and political apparel, the board issued, or rather the staff issued, obviously the board was aware of it being issued, guidance with respect to political apparel on June 20th, essentially outlining that our law is consistent with the Minnesota decision, and that and just reiterated to the local boards how to interpret the political apparel issue through the lens of electioneering, which provides a clear standard to follow, which was what was lacking in the Minnesota case, where the Supreme Court said that the Minnesota statute, in terms of its application at least, was unconstitutional. Let's see, and with respect to the work of the compliance unit, with respect to the January periodic, there are remaining outstanding 2,207 failures to file out of the original 2,530 that were made for the January periodic. That's roughly 87%. In terms of looking at the basic numbers for deficiencies, there are 1,137 outstanding items that are deficient still, that were identified, that are resolved. The unit, since inception, has received, now we've gone over 100,000 campaign finance reports, and the number that have been reviewed in some manner is 91,272. So we're fast approaching the 100,000 review mark, which will be a significant milestone.
Since when, Brian?
Since the inception of the campaign finance.
What was that, July of?
June 2014.
So it's over a 4-year period?
Yes. And that's all I've got.
Okay. Any questions for the Kim, I just wanted to go back a second on that on the IE regs, and you're talking to Facebook, you mentioned.
Yeah, they wanna talk.
Do we know how many platforms are gonna be affected by this particular regulation?
No. It depends on how it finally comes out. If we stick with the 50 million unique hits number, it's on that chart that they recently just sent us. It's, I don't
Actually,
know,
it's close to 50. I'm gonna
is it
look
close
right
to
now.
50? You're gonna look right,
Yeah, but I believe it's close to 50 platforms.
with 50 million, and then if we move it up to a greater number of hits, which some people have suggested, it will decrease the amount. I mean, we have to, some of those on the list that they provided late Friday are purely news organizations and things like that, so we're really gonna have to take a hard look at the number, I think, and talk about it amongst the various stakeholders and see where the real thresholds should lie. I think what I view just personally, is that most people are putting the attributions on everything now, because they don't wanna deal with anything.
On their own?
Yeah.
You mean without any
Without being
government
covered under a
obligation?
platform. Facebook is requiring that now, and some of the bigger people are, so,
Yeah,
It was 48.
48.
okay. Any other questions? No, okay, thank you.
Thanks, Nick.
And then we'll go on to election operations, Tom Conley and Brendan LaValla.
Thank you, Commissioner. Let's see, for the April 24th special election, we aggregated and prepared the documentation that you signed as the Board of Canvassers earlier. We'll be posting those results on the website. For the June 26th primary, we provided the counties with the certification since the last meeting. We've been working with them with regard to guidance on running small party primaries, reviewing their candidate notices, and making changes where necessary. We've been getting updated poll site information so we can make sure that the information we're providing to the public is up to date. And also been working with them on, as Todd mentioned, I believe, their plans for reporting election results on election night. For the general election, we received 8 nominations for governor, 8 for lieutenant governor, 8 for comptroller, 10 for attorney general, along with all related acceptances and authorizations for these and other offices to be filled at the general election. We prepared a prima facie report for your action later in the meeting. We'll be providing an amended March certification due to a vacancy in the first JD, as well as a revised emblem for the Reform Party, which we received. So we'll be sending that information out to all the different counties. For voting machines, we've completed our functional testing of the Dominion ImageCast Evolution, or ICE machine. We'll be finalizing those reports in anticipation of presenting them to you at the next meeting. We'll be scheduling our public demonstration of that system for next Monday, July 2nd at 11 a.m. We did receive from Dominion a review by SLI of an engineering change order, which was just for a replacement monitor used by the existing ImageCast because of end-of-life issues. Clear Ballot has also submitted an application for a modification of their system for the Clear Count system, which is used for central count and now allowed for use for the automated audit. The changes are largely affecting the software application in a couple different areas, reporting, user interface logs, etc. But that information is still kind of coming in, so we'll be reviewing that, and I'll be providing more information to you going forward.
So Tom, let me ask you, when you get an application for a modification to an existing system, what happens then? You review it, you test it?
So it depends on what the modification is going to be. Obviously, if it's a matter of software changes, there'll be a review of the code. There'll be some functional testing as well. There's a whole barrage of testing that has to be done based on what it is. If it's hardware, then there'll be also like additional security testing. So it kind of really depends on what the specific modification is. In this case, my understanding that for, let's say, with Clear Ballot, a lot of it is changes to their software application based on feedback that they've received both from their customers and from us, from the initial review of its use as a central count system and also from an auditing standpoint. So there are certain things that they simply, they have to change the core system because of the way that their application was built. And because they're changing that core system, it requires a little bit more in-depth review to make sure that any code changes don't affect things that we've already looked at. So, with regard to cybersecurity, as mentioned earlier, since the last meeting, we did have the 6 tabletop exercises across the state. I did present at all 6 of them. I thought that it was a very
useful endeavor. We did get a lot of good feedback from both the county boards and from county IT folks. We will be receiving an after-action report from the Department of Homeland Security probably mid-July. I think it's July 18th, at which point they kind of will summarize their take on the discussions that happen at each of these events, any feedback that we receive from on the feedback forums. So we look forward to that report, and I want to again publicly thank the Department of Homeland Security for helping us facilitate these tabletops. They did a great job providing staffing, providing materials, doing a lot of the presentations. So it was a lot of work, and it did not cost us anything to do that. So, and then obviously we've been discussing the cybersecurity plan that you had previously approved. So we've continued to be on phone calls and planning meetings with regard to implementing that with ITS and OGS and all the other state agencies involved. A couple miscellaneous things. We have begun reviewing resumes and interviewing candidates for some of the new cyber positions that are part of the Secure Election Center, which is kind of the embodiment of our cybersecurity plan. We'll continue to do that as more resumes come in. We have completed the review and evaluation of documents that were submitted for our new contract with an independent testing lab. We had received only one bid, and so we had to go through and evaluate the bid that they submitted, and we provided that back to OGS, and so hopefully that will be awarded soon, since contract is up in a few months. Staff visited 15 different boards for asset audits. We do continue to receive and process documentation from county boards with regard to their shoebox contracts. We have a conference call scheduled for this Friday with the Center for Civic Design on a usability standpoint. To focus on the usability of the 2018 general election ballot, along with some other topics about usability and best practices for some of the other stuff, but we're prioritizing the general election ballot for right now. With that said, Brendan, do you have anything else?
I'm good. Okay, any questions? Okay, thank you.
Thank you.
We will move on then to NVRA, John Conklin and Cheryl Kauser.
Thanks, Commissioner. The Public Information Office has been very busy since the last meeting. We received a lot of inquiries from the public and the press around tomorrow's primary. As I stated earlier, we have 20 primaries in 15 districts around the state. We continue to get a lot of questions about ballot access process for the state legislature, which will be next month. Also, we received a lot of questions about the governor's executive order and the pardons for the parolees. We also received a lot of questions about the Supreme Court decision that Brian mentioned about political apparel on the poll sites and whether that affected New York state law.
John, if I could interrupt you a second. On the, as far as the parolees are concerned, I've read a couple of articles from school districts who have been complaining about having convicted felons in there, in with children, et cetera. I don't know whether, maybe Tom or you have received phone calls on this, or anybody for that matter. How are we handling that on our end?
Well, I would say anecdotally we have seen a number of stories about complaints from either school districts or parents to boards of elections. Some parents have called us as well, complaining about the possibility of felons being in poll sites as a result of the governor's executive order. I did see a story in the Rochester area about the Monroe County Board and one of the commissioners there being asked by the press about, have you been contacted by schools asking about not being poll sites, and he acknowledged that he had and that they were working through those issues on the local level. It seems to be an issue that is bubbling up. Initially, when the governor discussed this, there was the idea that there was a criteria that they were using to grant the pardons. As this has gone on, it's become clear that there isn't any criteria that they're being given out automatically. So it is for any felon, level 3 sex offenders, capital murderers, etc. So this has become an issue in the general public's eye about who's in the poll site with them, and a number of the school districts are concerned because they're a target to start with, and now they may have people in their facilities on election day that they don't know anything about, and it's concerning school districts and parents. So if it continues to build momentum, if school districts or schools were to become unavailable to us as poll sites, that would be a calamity for the Board of Elections statewide, because every county uses a large number of schools for poll sites. So that may be a consequence we have to deal with down the road, we are seeing stories about it and anecdotally hearing complaints about it.
They would have, they would have to, if we deemed it. Each of those poll sites, however, in spite of the fact that the school district may say, no, we don't want them, they'd have no choice as far as.
Statute can force the school district to be a poll site. The Board of Elections has the upper hand by statute that they can force them to be that. But if the general public becomes averse to it, then, it's only a statutory requirement that can all be changed by the legislature at any time, and if the general public becomes opposed to it, they will go to the legislature and express their views, so,
Yeah, but I don't understand why people are so concerned. If they're sex offenders and they have orders not to go near the schools, they're not going near the schools, all right? Unless there's a probation officer, or we used to have monitors in my county that stayed with them. And these are the same people who go to your supermarket, go to the cleaners, and you don't know who they are, all the time. And people are with them all the time. Why are they so concerned about voting in a school? I'm talking about the adults now, not the kids. Kids have to be protected in terms of that. But if people who are on parole go into a school and walk around and vote and walk out, I don't see that as dangerous. I think it's more dangerous in the supermarket, believe it or not, and that happens every day.
Just my personal opinion is I think that because the issue is highlighted, people focus on it.
No, I agree with that, but
And
I'm
I
just
think
trying
they
to put
think
it in
the schools,
perspective, that's all.
I think they think the schools are already targeted and they're afraid of their kids going to
Understand.
school. And now there's these pictures of people or of the few that violate or do whatever, and they're just concerned about it because it's the issue of the moment.
No, I understand that, and I just wanted to put the conversation
Yeah.
that we're having here in perspective, that's all.
I think one other statement we should clarify is that there are no standards. Certainly there
They
are,
admitted that in the paper.
they have not shared those with us, but of the, about almost 9,000 to 12,000 of the persons who are on parole were not granted one of these probationary, not everyone on probation received one, or excuse me, parole received
Well,
one.
I think the governor said
So-
there are no
So
standards.
clearly, not everybody got one, so they're not just given out automatically. What those are, I don't know, they haven't been shared. But persons who complete their maximum term of imprisonment, who have no need for any other document in order to register to vote, are still on the lists of persons who can't go near schools, depending on their situation.
That's not good.
So if they have a continuing supervision related to, they're on a sex offender list at a certain level, they can never go near the school unless they're taken off that list, or certain other places. So that per se hasn't changed with this situation.
Well, just because we're talking more about it now, I wasn't going to comment on this, but I think the main concern with people, at least that I've talked to, is that the governor's office has essentially admitted that there are no criteria, and we can talk about that or whatever it is, they believe it's fundamental right. So, and as do most people voting. I think the problem is it's easy to get a pardon and it's hard to get it away. For example, when you have someone that's initially given the pardon, the voting pardon, and then they're reincarcerated, that initial partial pardon is not going to be reviewed until that particular person is sent to a state prison. And only then will it be reviewed. It's not, I think the concern is it's not automatically revoked upon reincarceration. So there's what could be several months of delay wherein county boards will have to send absentee ballots to prisons, to people to vote that have been convicted of a felony, that have been reincarcerated by the time the governor's office reviews it.
And
That's-
if that's true, I agree with you.
There's a couple of
It is-
things
it
that
is true.
I would just like to add to those comments. Is that in the guidance that we gave and that is very clear, is that if someone who's received a voting pardon is convicted of another felony that would result in forfeiture, the new forfeiture trumps the
When we get it from
pardon.
OCA.
Yes, which is exactly the same as if they were able to vote yesterday. It's going to take
Right.
however long that process does, which is something I always point out when these discussions come up. Robust list maintenance is very important, but we don't have elections every single day. We tend to have elections 2, 3, 4 times a year, depending on whether or not someone lives in a district or a special election, whether or not there are primaries and things like that. And so that with all of our list maintenance processes, while we try to make them as robust as possible, most of them do not occur in real time. And the governor's office was very clear that they were working on a process with respect to the rescission aspect of the pardons, and that they would begin sending lists of those, and I'm sure they would be working to make that process robust also.
Mr. Spano, just to your point, there was an article recently in the Miami Herald about a gentleman that was in Livingston County. He was convicted of strangulation, which is a Class B felony. He got out in September. He was granted a partial pardon to vote. He has since been reincarcerated for a violation being on the internet and soliciting people. What has happened is, if you look him up now, it says voting pardon issued, but his status is incarcerated violation. So Brian is correct. When they commit a new felony and they are ultimately convicted, if they are, OCA will notify us of that and they will be purged just like the same person yesterday is today. The real issue to me, and to many, I think, is the gray area of a parole violation, dirty urine, curfew, on the internet, whatever. The parole officer picks you up, files a warrant in the local jail, and you sit there. The governor's office was clear that those people will only be reviewed if the ultimate disposition is them being reincarcerated in a state facility. It matters not that they've been violated on parole and are waiting for the hearing. And I think that's where people, about getting it back, if it was automatic revocation upon reincarceration, I think that a lot of people are saying, well, didn't they called from Livingston County, didn't he lose it? No, he didn't lose it, but he's going to be reviewed.
That's a different issue than being frightened every time you go to a polling place. And that's
Well,
what
I agree, that is a different issue.
That's what I was addressing.
No, I agree.
We tend to take, in every situation, there are going to be incidents. Every single, I don't
I
care
agree.
what you mention, there's going to be an incident. If you want to take that as proof that there's a problem, go ahead. But we used to send kids to church, and they were years ago, and they had big problems.
No, I agree.
And we still doing it.
I agree. Like I said to your other comment, I think it's just been highlighted because of the school situations, and this issue has risen to the forefront. I said if people really thought about it, you're 100% correct that most people on community supervision live amongst us every day. They could be sitting next to us, for all I know. I just think that's the focus of this particular point at this time.
On a policy point, with respect to the behavior of Board of Elections on the issues related to schools as poll sites generally, because we have had other issues, Kim alluded to them, with respect to concerns about schools as poll sites. When you pull the community in and you have the potential of the school population and the general population being in the same space. Most boards of elections and most schools now have a much higher degree of sensitivity about designing how they use schools as polling places to ensure safety of the children in schools. And I think that's a credit to the sensitivity of the election community. I think that the public should be pretty confident that the voting process is being undertaken in schools in a manner that both preserves democracy and the safety of their children.
Well, the reason I brought it up too was that, as far as our board is concerned, this could wind up dumped in our lap, and I don't think we have any kind of a solution for it. If there's, let's say for the sake of argument, and I use the word sort of loosely, if there's a panic among various superintendents of schools that say, no, we don't want it, and all of a sudden we wind up with, dozens or hundreds of polling places that we can't use, that becomes a serious problem as far as this board is concerned, and I don't think there's any, at this juncture, any way that we can resolve it.
But my comment, and I agree with what you said, and bringing it up that way. But my problem is with perpetuating that kind of attitude and constantly talking about it like that's real in terms of the danger. the danger is minimal, just like it is walking into the supermarket. And I don't think we should look at that issue. This is a real issue about using the schools and getting. So by talking about it in terms of danger, we're compounding the issue you talk about. That's all.
People are nervous, that's all.
They're always nervous.
Well,
If you put a referendum out for streets, they want rubber, so the kids bounce off. Come on.
But the distinction between before and now is the public policy of the state before was that you were not restored to your voting rights until you had served all of your incarceration and been discharged from parole. So you had met all the qualifications for parole. You had done everything your parole officer had asked you to do, and then you were restored to your rights. As far as we can tell, none of that analysis is being done anymore. And the restoration of the voting rights has been moved up in the process. When you're out of prison for a month, there is no monitoring showing that you've met all your obligations under parole because you've been granted your pardon when you're out a month. So
I'm not arguing that point.
I don't think that.
I'm
point's correct.
arguing the point about danger. That's all, about perpetuating this concept of
We've
terrible
had people
danger.
1
That's
month
all
out, 2 months out.
You're arguing a point that might not be an appropriate policy for voters and what happened in the past. That's okay, I can agree with a lot of this. It's perpetuating the concept of danger in the polling places that bothers me, because that gets us to the problem that we just talked about using the schools.
but just so you know, that issue is coming up. We're not pushing it down.
But part of the issue is though that the people who have been placed on parole have been released from incarceration and are moving about in society already. And yes, they do have other conditions, on their parole, but the fundamental quote-unquote danger that's presented by someone, and which I think has been grossly overstated in the manner that the commissioner has said, but is that they're able to move in civil society. And so the only space that we're talking about is their ability to move into a poll site.
Sometimes. Halfway houses, there's a lot of things.
Yeah, I mean, Brian, I think to be fair, it's not about poll sites, it's about schools, frankly. I mean, the concerns I've read isn't that they're appearing necessarily in poll sites, but that they're appearing in schools. And this has been an ongoing issue in the state for a long time, about schools being concerned about them, right, before this, but they're being used as poll sites in this state. And I think administrators and parents have a heightened awareness of the vulnerability of the student population in these schools, and allowing people in their doors that they don't know who they are. I mean, I know now large times when you go to your school, you have to check in. You can't just go to the school and walk in the door anymore. You have to go to the office, you have to check in. I remember when my kids were in school, I couldn't just walk in and get them. I had to go to the office, I had to prove who I was, I had to tell them what I was there for, and there was a very heightened security measure there because of the students. So I don't characterize this as a poll site issue, I characterize it as a school issue, but fortunately or unfortunately in New York State, schools are predominant poll sites, and certainly upstate, and I think even in New York City, schools are largely used as poll sites. So I think that's where the issue arises.
Yeah, but you remember that we supported legislation this year that would close the schools on
Yeah,
election day.
fair enough.
Which would get this,
Right.
this problem someplace
Fair
else.
Fair enough.
Okay.
It may come to that, too.
Well, I
But a
think
lot of the
it's a good
school
idea.
districts upstate oppose that because it narrows the number of educational days they have available.
Which is another arbitrary number.
Yeah.
Being an educator for over 25 years, I can tell you it doesn't matter goddamn where the kid's in, 1 day more or 2 days less. Am I allowed to say that here?
You're right.
You did.
We'll get that in a minute.
Okay.
Back to me.
Anything else? Yeah. I'm sorry, John, you're still on, I believe, as far as your report goes.
So,
But it's been rather long-winded, so if you'd come speak.
I'll accelerate it a little bit. So Tom already mentioned the tabletop exercises. We were part of that as well. We got some good local press for each tabletop exercise that we had around the state. We've also received some good national and international press on the tabletop exercises. So we participated in the monthly ECA call in May. We've done 101 FOIA requests in May. The unit's also been part of the discussions, as Kim mentioned, on the Eason lawsuit with the counsel's office and IT. With regard to the website, we posted the nominations that Tom mentioned for the September 13th primary. The annual report is now posted. There were some typos I had to fix, and it was delayed because of my involvement with the tabletops, but they are now fixed and the annual report is posted. The webcast and the transcript for the May 3rd meeting has been posted. The transcript and the agenda for the May 8th meeting was posted. We'll have an audio file up this week for that as well. The election night results page for the federal primary will be posted tomorrow. We'll post the certified results that you gentlemen signed today. They'll be moved to the election results page. We received the final PDF for the 2018 version of the law book. That will go up soon. At Commissioner Kellner's suggestion, we posted the newly adopted automated audit request regulation on the website as well. I think that's a good idea. Previously, what we did with the regulations was we had to type them ourselves and then they would go up on a PDF. Then we found a way to access a Westlaw location for all of the regulations, but they don't update them quickly enough. So at least as an interim step, posting what we've adopted is what we've decided to do. So the website reg that will likely be approved later in this meeting will also go up shortly. For NVRA, we had 7 trainings around the state since the last board meeting: Albany, Elmira, Buffalo, Syracuse, Glens Falls, Hauppauge, and Fishkill. Over 240 people attended those trainings for the Office of Temporary and Disability Assistance. The next training will be in Harlem this week. We've also visited 8 boards for visits: Broome, Chemung, Madison, Orange, Clinton, Franklin, St. Lawrence, and Lewis County. And they were all positive. They all, were found to be compliant in their procedures. So, Cheryl, do you have anything to add?
No, thank you.
Okay.
Okay, thank you. Any other questions of John or Cheryl? Okay, then we will move on to ITU. William Cross.
Good afternoon, Commissioners. Start with projects. Campus FIDUS, the development continues on the EFS, both itemized and non-itemized transactions, ballot access, and data conversion. But as mentioned earlier here, we've had to divert several staff to address the new digital ads application, both in creating the short-term solution to meet the legislative requirements and the time frame required, but also integrating that functionality into the fuller project. Since that effort's underway, we don't yet know the impact on the overall schedule, but we're adding additional contractor-based programmers to hopefully minimize any of that impact. We will be updating the schedule based on the progress of the digital ads, as well as when we have some timing on onboarding the contractors. I'll relate that to you then. I am happy to report we've completed several interviews for the state-based programmer that we've had a vacancy for and made an offer. That person was accepted and starts Thursday. For Nice Voter, as reported last month, we've completed the Nice Voter application. Has been migrated to the new infrastructure. We continue to work on some tuning around that and adding some additional legacy functionality, bringing that over to the new infrastructure, and working with the vendor to finalize project deliverables such as documentation and such for that. And it's been mentioned multiple times, we're also prepared the election night reporting system for tomorrow's election. Data center relocation, we successfully relocated our entire data center, including about approximately 100 servers, to the new location on May 19th. The move was completed with a minimum of problems, and all systems are back online for Monday morning. I'd really like to thank my staff for their hard work in completing both migrations, essentially major migrations, Nice Voter and Data Center, back-to-back successfully with minimal problems during that time frame. And Move, we're also continuing on the development in the in-house Move application, for the outsourced application. Security, I think much of this has been mentioned already by others, but I'll just throw in our involvement. My involvement in each is I attended all 6 tabletop exercises across the state. Was happy to see involvement not just from county boards of elections and county IT, but a pretty diverse group of also PIOs, council, local law enforcement, all attended. We received good feedback from them as well. It seems like everybody has a part in those efforts. IT also continues to work with the rest of BOE on the implementation of the Secure Election Center, including staffing and development of the acquisitions that I think Bob mentioned, was risk assessment.
Bill, can I ask you a question? I'm sorry to interrupt, but
Yeah.
let me just, back to your tabletop.
Yep.
Do you know how many counties in the state BOEs have their own IT unit?
Minimal. I don't have an exact quantity, but I would say it's a very, very small percentage.
Single digits?
Yeah.
Yes.
Yes.
So,
Single hand.
Yeah.
single digit.
Right, and
So
many-
you're dealing primarily with IT units that are county,
Right.
serve the whole county, don't just serve the
They
Board of
serve, they
Elections.
serve the whole county, which BOE.
So you
this
found
month
that
of-
in large part in these tabletop exercises, those people also attended your,
They did, and in many cases, we found out that in most cases, they have a pretty good working relationship with their county boards. There were some that came together and had never met each other before, but this facilitated communication between them, so that was very useful. I think if nothing else, between those kind of two parties, it really got away from each thinking it's the other's job when something happens. They realize that they both have a stake in this and they need to work together and communicate further. I will note in some of even the boards that have dedicated IT staff, they're at a certain level of IT, but then they still draw on the county IT. They're not totally separate. They may provide upfront support and maybe a localized support of that county's board's infrastructure, but they still work with the larger entity as a whole. And I think in all cases both were represented, even where they had county board IT, both were represented there. But we had a good mix of.
Just with the counties, Todd and I had reached out in 2016 to NYSEC's leadership, and they've been very good to work with to put the word out to the counties from the county chief elect, whether they're chief elected or whether they are appointed managers, that their IT departments need to work together and help us in this process. We did a webinar in the library with NYSEC, reaching out to their members, pretty much telling them what are we doing with the grant money, the plan you approved, the tabletop exercises, how we have this opportunity with $25 million to identify the risks and fix as many of them as possible, train people, and to put together a security toolbox, that we basically need their input on how best to do that. And I think that outreach, I know the staff also been reaching out to NYSBOE, if I could remember what that all stands for, but it's basically the local county, it's the Association of County IT Directors.
New York State Local Government IT Directors Association.
Whatever that acronym is. So really, the partnership is to do the risk assessment and then get their input as to how to use this money to improve the situation as much as we can. So it's really a partnership, and I think they appreciate us asking them for their views, and I think that's helped at the local level for the, when an IT director is busy already, election invites them, but also the county leadership is saying go.
good. Sorry to interrupt.
No problem. The acquisitions we're working on as part of the Secure Election Center, risk assessment for each of the counties, intrusion detection systems for the county boards, and then a larger effort of ongoing monitoring services for several counties that need it, that may already have their infrastructure, or even ourselves. BOE presented on the topic of securing our election at NYSBOE on May 15th. And staff also attended the multi-state ISAC and Elections Infrastructure ISAC, or Information Sharing and Analysis Center, open house in May, along with Cheryl from PIO. Website analytics, basically traffic looks normal, a little over 200,000 page views for the month of May, which is consistent with April. And IT has been working with each of the program areas within the Board of Elections on the accessibility issues and enumerating website content, what needs to be resolved, what still needs to be remediated, and coming up with a project plan for that. That's all.
Is that it? Okay. Any questions of Bill? Okay, thank you. And move on to enforcement, Risa Sugarman.
Good afternoon, Commissioners. We've been spending our that you drafted to the Part 6203. I anticipate filing those on Wednesday. As Kim mentioned, there have been 9 public comments filed in response to the request for public comments, and I would request, I have asked both Todd and Bob, and they have, actually Bob said no. I would request that those public comments be posted on the website. There were 7 from individual citizens in New York State, 1 from former members of the Moreland Commission, and 1 from reInvent Albany. And I believe that the public has a right to see those public comments before the commissioners vote on the regulations on, I believe, August 8th is the when you're planning on voting on those. I also would ask the commissioners to provide for time for public comments or people of the public to come on the 8th and make statements to the board on that date. And I would request time on that date to make further public comments to the board in reference to those regulations. And if you
Is
don't,
that your report?
yes, if you don't,
You're not going to tell us what you've done in the last month?
that's my report. And if you, may I just finish one?
I thought you did finish.
If
Go ahead
you-
and finish.
If you are not predisposed to let me speak as to the regulations, I would just like to know that in advance.
Well, we'll take those under consideration, your requests.
And just let me know if you don't, you're not going to allow me to speak.
Sure. Sure, we will. We'll let you know.
Thank you.
Did anybody else have anything else? Do you want to? I had something I wanted to ask Risa if I could before. And this goes to our last, actually the board meeting of May 3rd. I just reviewed some comments, and there was a discussion with Commissioner Kellner that you had about the number of referrals that you've made over the past year, I believe, to district attorneys and the Attorney General. I'll just read. Commissioner Kellner asked, and I'll read from the transcript, obviously none of these have been referred to the district attorneys without going through the commissioners, right? And your response was, well, the district attorney's offices have original jurisdiction, and referral to the AG have gone through the commissioners. And I was just curious from that response, is your position that referrals to the AG are the only referrals that have to go through the board? Or do you agree that all the referrals from your unit have to go through the board, whether it goes to the AG or to a district attorney?
I said that the Attorney General would need a referral, and a district attorney would not. So that if a district attorney is investigating a matter, they do not need a referral from the commissioners.
Okay. So I just wanted to clarify then. So you agree that if a referral's coming through this office to a district attorney, that has to go through the board and can't be made outside a board meeting and the commissioners vote?
I don't know what that means through the board. I don't know what you mean.
What I mean by that is there would have to be a formal request brought to the commissioners to make a referral to a district attorney on a matter that's been investigated by this office.
Well, I don't know
and
that I-
then, let me just finish.
Go ahead.
And that at that point, a vote would be taken here at the board, and if there's a tie, of course, you can participate, before that referral would be made to the district attorney.
I don't know that if a district attorney asks for my assistance, that would be accurate.
So you're distinguishing between a district attorney asking you for something as opposed to you sending them something? Is that the distinction?
I don't know whether that's, I mean, if the district attorney is conducting a grand jury investigation and asks for my assistance, I don't know that they have to go through, there has to be a referral through the board.
Yeah, no, I don't think that's what I'm referring to. What I'm referring to is if you are
If I
really the
initiate
instigator,
something
yes,
and
correct,
conduct the investigation
correct,
through the division,
correct.
that I believe would go through the board.
Okay, I just wanted to clarify that because that wording, I wasn't sure exactly what
But
you
if a
were.
district attorney is investigating something through
They
the
can always
grand
do
jury.
that.
Yeah, I mean, I do
Yeah,
agree.
she did.
I agree DAs have original jurisdiction in all these
Mm-hmm.
matters. I don't disagree with that, but the way you responded, it sounded to me that maybe your position was only referrals to the AG go through.
No, if I am conducting something through my division
Right.
and the district attorney is not investigating through the grand jury, I don't have the authority just to
Okay.
send it.
Fair enough. I just wanted to clarify that. Okay, all right. That's all. Anybody else have anything for Risa? No? Okay, then that completes the unit reports for today. And now we'll go under old business. Unless anybody else has anything else they want to bring up before we go to old business? No? Then we will go on to old business, and old business today is the adoption of Part 6215 of our rules and regs relating to candidate websites. I believe this was in response to a piece of legislation that was adopted earlier. And this is final adoption, I believe, that we're entertaining today. This has gone through the hearing or through the review process. And have there been any comments that came back on this one?
There have been no comments.
No comments at all. So today's action would be a final adoption. Is there any comments, motions?
I move that we adopt the regulation.
I'll second that.
It's been moved and seconded that we adopt. All in favor?
Aye.
Opposed? So those are adopted. And they are in final form and they'll be put out accordingly. Okay, good. So that completes our old business, unless there's any other old business somebody wants to bring up. Okay, seeing none, we'll go on to new business. New business, the first one today. Excess rulings, and this goes to the, I believe, statewide candidates that were filed here. I believe Tom alluded to this earlier with a number. And in front of us, we have one recommendation from the staff. There's a prima facie defect in a nomination that was filed here, a designation that was filed here for New York State Attorney General. And that was on the Reform Party line. That was for Preet Bharara. And the recommendation is to make that invalid due to the lack of an acceptance of that designation.
So moved.
Is there a second? Yeah, all in favor?
Aye.
Aye.
Opposed? So that recommendation by the staff is adopted. And there's no other prima facie rulings that are coming before us today, so we'll move on to our second item, which is an opinion on charitable trusts. This relates to a charitable giving fund, and this is an opinion, an advisory opinion relating to the legality of a campaign committee giving their money to a charitable giving fund and the authority to do that. Is there any discussion about this proposed opinion? No discussion? Is there a motion to adopt?
I'll move that its adoption as it has been revised.
As written?
Yeah,
Okay.
as written.
Is there a second?
I second.
And all in favor?
Aye.
Aye.
And opposed, so that is adopted as well. The next is an opinion on childcare. This is an opinion, and it relates to the ability of a candidate or an office holder to use their campaign monies for childcare purposes.
So, this opinion was prompted by the recent revision of the policy by the Federal Election Commission to allow campaign committees to expend funds for childcare where it's reasonably necessary and related to the campaign. New York, we issued an opinion before our time in 1987, although maybe
No,
you
before your time, I
All
was
right.
here. It was in the early 90s, yes, we did.
Okay. That puts childcare expenditures in the category of personal use, which is prohibited by the statute. And I think that the time has come for us to follow the Federal Election Commission and reverse that policy. Now, as to the details, however, the devil is always in the details. I think that we can all agree that if someone is incurring babysitting expenses so that they can go out campaigning, that's a legitimate campaign expense, that they would not otherwise be able to campaign without that. New York, the statute ties both campaigning and for use in public office in the same phraseology. So you have the additional problem then of, well, if it's okay to pay for your babysitter to go to a campaign event, is it okay to pay for child care to while you're performing your public office? There are many out there who say yes. There are many who say, well, wait, that's really an abuse, because public officials will then be able to go out and raise money to pay for their child care. I think the opinion is a good one, and I support it. But I think that what we should do is, instead of adopting it at this meeting, that we should put it out for public comment and see what the public reaction is, and whether there should be some finer distinctions added in the opinion than what we have drafted here.
Okay, I just have a couple comments, if I can, then before we, was there ever a request, was there like a formal request made of the office to issue this opinion?
Not a formal request, but several legislators contacted me immediately after the FEC ruling.
Okay.
And asked that we follow the FEC.
Okay.
We also did have a phone call that Nick fielded from a treasurer who did ask the question in a generic sense.
Because typically, I think in these in these 14130 personal use area, we issue opinions based on a formal request made by somebody, which delineates what the situation is, and then we respond to that. I would note that the federal opinion that's being cited, and I've read about it, it's in the paper. It's actually a candidate here in New York, congressional candidate here in New York, I guess, that asked. And the opinion, talks to the specific circumstances of that particular candidate. I mean, for example, that candidate was the caregiver in this situation, apparently. They go on, the request explains that you are the full-time caregiver for your young children, that because of your campaign activity, you'll incur expenses for part-time or full-time child care. So it really goes to a specific circumstance where this candidate was the full-time caregiver, is now a candidate for congressional office, wants, I'm guessing, to go out and campaign and would pay for the caregiver because they'll no longer be able to do it. So it sort of is a but-for test, that but for that campaign, they would not incur those expenses. Fair enough. And, but the opinion, I think, rests on those facts that were apparently delineated in the request made to the FEC. That's not what the opinion that's before us here today does. It really gives more of a generic view of the statute, looks at the language in the statute and then makes a conclusion based on that. Personally, I'm more comfortable with looking at it in the context of a specific request that lays out a set of facts, and then we respond to those facts, trying to draw from those facts as much as we can as to how this would impact people in at least a similar circumstance, if not exactly the same. I'm okay putting something out, but I want it out there that, my concern is I don't want us to be opening up this to just people's interpretation and just it's okay to have childcare under any circumstances if you happen to be a candidate or you happen to be an office holder. I think that it should be determined by the facts. I think the way this opinion is crafted, for example, this before us today, it talks about, that you have to have a direct relationship between the campaign expense and the child care. I agree with that because I think that's always the case when you're looking at a 14-130 analysis, but I don't think the opinion helps very much in determining when does that occur. When is there this direct relationship? That's what I think people want to know. I think in the case of the FEC opinion, they gave a very specific idea that this happens when you're the caregiver. Oh, now I have to campaign and I can't do the caregiving anymore. Somebody has to do it. I'm going to pay for it out of my campaign account. Okay, but for your campaigning, you wouldn't have this expense. That makes sense to me. But I think to do it in a more just generic, there has to be some direct relationship. Well, that's the general rule.
Well, Peter, how about you're the primary caregiver. You run for the assembly and you're elected to the assembly. And now you have to go to Albany 3 days a week for 6 months a year.
Mm-hmm.
What's the rule?
Well, I think that's a good question. I think that's a legitimate case. I mean, I think but for the fact that I got elected and I used to be home watching my child and now I'm going to Albany instead, there's an argument to be made that but for my holding of office, I would still be the child's caregiver. I would not have that expense. Now I do. There's a legitimate relationship between my office and the child's caregiver needs.
I think that's good. I'm all for it. I think it's just a question of articulating it so that we can give some guidance to people on what's okay and what's not okay.
I do too. I mean, I'm all in favor of giving guidance. I think that's what we should do as a board. But I just felt this particular, first of all, the way this one came up to me was unusual. There was no specific request. There was just a general request. Could you do something since the FEC's done something? But again, I think if you read the FEC, it is based on a very specific request in a specific circumstance. Fine, but that doesn't mean we're going to follow it rote, but it also doesn't mean we're just going to open it up. So I would be more comfortable if we had a specific request, but if we're willing to go out and do something in this area, I still would like to delineate it better as to when we think the direct relationship that's necessary actually occurs, not just say, you need a direct relationship. That to me is open to too much interpretation. And I think the point of our opinions is to try to define for you what is that direct relationship. So I know as an office holder or a candidate, have I met the criteria that the board's looking for to determine this is direct and direct enough to warrant my use of campaign money.
Some of that will probably come back in public comment, I would think.
That sounds good to me.
That's fine.
And I think
If
we
they-
should try
if
to
they
do that.
want to give
I
comment.
agree.
Okay, and Risa wants to comment. Go
Yeah, I
ahead.
just would like to call your attention to subdivision 6 of
Oh.
14-130.
Subdivision 6 of
Which
14-130. Okay.
The State Board of Elections shall issue advisory opinions upon request regarding expenditures that may or may not be considered personal use of contributions. Any formal or informal advisory opinion issued by a majority vote of the commissioner of the State Board shall be binding on the board, the Chief Enforcement Council established by 3A of Section 3-100 of this chapter, and in any subsequent civil or criminal action or proceeding or administrative proceedings. So I would say that your suggestion that it be a specific request is in line with what the statute would require.
Well, I think we have a specific, at least the way I understand it, we have a request. It didn't come in writing, apparently, but we
Right.
have a request. I'm not arguing with that, really. We do apparently have a request. as I said, I'd prefer something that was more detailed maybe, so
Well,
we
it
could
says
respond to that.
that request regarding expenditures that may or may not be considered. I think that it would be better, as you say, that it go to the specifics of like it did in the FEC request.
Yeah, fair enough. And I do think that if we do issue opinion here, we should delineate it more than the one that's in front of us is delineated as far as what types of circumstances we think warrant this kind of treatment, rather than just saying, as long as you have a direct relationship, it's okay. I don't think that's enough. I think that's what the statute says in essence, but I think the statute has tried, which it never did in the past, to delineate much more specifically when the legislatures determined this is a legitimate direct relationship. It used to be just very vague. Now they've delineated it a lot more, which I thought was a very helpful thing to do, but I think we should be doing the same. And I think it would be better if we delineated better in this opinion.
Good. So I move that we put this over to the next meeting.
Okay. All right, and any disagreement with that or
No.
anything else? Okay, then we're done with.
Are we posting it?
Yeah, post the first draft and
I'm
if
okay
there are
with that, I mean,
revisions.
if you want to, but just know, if you bring it back, I'm looking for more specifics.
And I agree with Commissioner Kosinski's
So,
comments.
You know, whatever the
So
comments
maybe
are,
you
those are
wanna,
mine.
maybe you wanna look at another draft before you, well, you could
Yeah.
post this one and then post another one too, if you have, if the two councils agree, I don't see a problem with you posting drafts.
Okay, I believe that's the end of our agenda, unless there's something else somebody wants to bring up.
When's our next meeting?
I believe we've already set it at August 8th. I think we have to do it that date, right? We're pretty tied into that August 8th date. Okay, so that will be our next meeting date. And is there any more business to come before the board here today? If not, I'll entertain a motion to adjourn.
So moved.
All in favor?
Aye.
Opposed? We're adjourned till August 8th. Thank you.